This paper has been, it's actually turned out to be a very interesting exercise in terms of enlightenment for me, in terms of the fact that I haven't spent as much time as I should have on the communication with juniors when I've had them. And so to all those who are here who I've led, I apologise for failing in the art of communication. And so it is, and for New Silks, I was talking to Shane just a while ago that I think it's very helpful for Silks to focus on the whole question when you're brought into a matter. What is it that I want? What is it I need? And to have an upfront conversation and an ongoing dialogue about those very matters. A number of people on the floor have assisted me with this in the sense they've provided their own thoughts and comments on the draft, and for that I thank them and I appreciate it. And the interesting theme amongst a lot of those comments was just that. It was mutual respect and it was communication, so that there's no, or you minimise the prospect of dislocation in the team when you're running a matter together. I was thinking, I think I was talking to Simon about it last night. I have certain things that I really don't like at a very practical level. I don't like double-sided paper. I don't read emails simply because they come in. I don't like people saying to me, well, didn't you get my email? I said, don't assume I look at the screen. I just don't. I only work on hard copy, so no one should expect that I'm going to sit there and look at the screen. And so these are, yeah, well, you can text me, but I just won't read it usually, or respond to it. So there are a lot of, they're just sort of menial things, but things that I hadn't really thought about sharing with anybody until something goes wrong, and then you get the shits about it, and that doesn't really help. So it's been enlightening for me, and so I've learned some things, and hopefully the Silks on the floor will too. The other thing that I've realised about the relationship with juniors is that the level of deference is often way too high and unnecessary. Like for those of the more confident juniors who I've worked with, subtly say to me, yes, well, your submissions are way too long. And it's true. And so if juniors say, look, you know, that could be expressed a lot shorter, I don't mind that at all. Once I've recorded what I want to say, if I've taken the burden of the draft, I'm more than happy for the juniors to say, look, I think I can do better than that, or let's shorten that up. Here it is in markup. I'm not precious enough to say it's got to be written the way I want to do it, but it's a bit late in the day to me to be changing my spots in terms of how I go about my work. And I think that's the sort of thing you need to have a dialogue about. I mean, whether the Silk is comfortable with you tinkering with things that are written. I think a lot of people are a bit prickly and unnecessarily about it. So that's an important matter, I think, about being prepared to speak up. But in terms of the paper which has been circulated, I don't need to go through it laboriously, and I'm hoping that there'll be some war stories. Let me just give you one straight off the bat, because it only occurred to me this morning. When I was very junior, Richard and I were doing a case before a commissioner down we must have been in the Pitt Street end where the Industrial Relations Commission used to be many years ago, and it was on at 9 o'clock for final submissions, we thought, and only for half an hour it was listed. We also he was leading me in the full federal court in a major industrial matter with Melbourne Silk on the other side at 10:15. And of course I knew nothing in real terms. I knew what the name of the matter is and I knew the client, but in terms of the legal arguments, I was really carrying the bags. I was at that end of the spectrum and stayed that way for a long time. Anyway, the matter ran on and on. It went longer than expected, and Richard's putting the submissions, and so he whispered to me, you better go, because I got to keep going with this. You've got to go up to the full federal court. So I arrived there, and there was Smithers and Everett, and I can't remember who the third one was. Northrop. And a Melbourne Silk called Brian, someone or other, who was a nice bloke. And he said they'd gone off the bench because I hadn't quite made it on time, or Richard hadn't made it on time. And fortunately, my opponent was very kind. He could see that I was as green as a bloody new banana. And he said, look, they'll be all right. They'll surely understand. And I thought, yeah, well, Richard will be here in minutes. And they came back on and said, yes, okay, Mr. Kimber, let's go. And I thought, gulp. I thought about Rumpole and whether I'd clutch my heart and fall down. I love that episode. I think that's great. But anyway, there was one point that I could talk about. It was a minor one. And so I started to rabbit on about that, and the presiding judge turned to Phil Everett and he said, what is he doing? Okay. And Everett said, and it was audible, he's stalling till Kenzie gets here. Fortunately, Richard's reputation was such that they were prepared to allow me to rabbit on for a few more minutes without ripping the bloody bejesus out of me for wasting their time on a menial point, but it was the only one I'd managed to get on top of. And there'll be others that are equally as disturbing as those that'll no doubt fall from what happens today. The reason that I started with this paper really was the idea about, and it really follows on from what I said in the last paper about what does a junior bar do, to secure their practices or to make them work, apart from diversifying. Well, working with silk is something that can really help you, but can also really hurt you. If anything, and those of you who read the paper know, but you know the adage about good news spreads fast and bad news spreads even faster. Both with working with silk and otherwise in terms of the quality of the work you do as a junior for other people, if it's good, it can help you enormously. If it's average, or worse still, if it's sloppy, it's going to hurt you, because next time round you might not get another shot. And so there is a real value, if you're going to do it, if you're going to work with silk, you want to be switched on and figure out, just what can I do to make this work for me? Because if you get it right, it will help you, and if you screw it up, it could hurt you. You won't get any repeat business, or you might not, from that silk, and that silk might tell other silk or tell solicitors that you're not really good, don't turn up, not really committed to the cause, got too much work, doesn't do things on time. A litany of things, mistakes that you can make that can hurt you a lot. I don't have a high level of tolerance. If I'm dealing with a new barrister for the first time and it doesn't go well, obviously there's more fish in the sea. And so if you say, well, okay, I've given that person a shot, but it didn't really work out, or alternatively, so you're more inclined to say, well, I'll give someone else a go. But so getting repeat business is what you're all about. So you need to make, winners out of the opportunities you get. So this paper is directed essentially to trying to figure out what you need to do to get good value out of it yourself and to enhance your reputation. And probably more important than the positives, I would say, is to avoid the negatives, because there are certain things that you can do, some of which are canvassed in here, that I think can be very, very damaging to you if you fail in that regard. And in coming back to the question of the issue I've written in the third paragraph there about, might not use people again because they're obtuse or lazy or struggle to get to the pitch of the ball, whatever it might be. And then I thought, from a junior's point of view, if you work with a silk that you don't have good experience with, either because they're lazy, obtuse, they don't get to the pitch of the ball, then you might well want to make your own decision to not encourage taking work from that particular silk. So you need to protect yourself from getting caught in a situation where you might be completely overused and abused, and or, I think some have commented, underused, so that you're bored to death and you feel like you're really a third nostril, that you've got nothing to do. And so there's reasons that you can protect yourself and proper basis for so doing. The issue of dodging, the other thing that you should know about it might be a little bit of a secret, but sometimes if you get saddled with a junior who you've worked with before, or you soon figured out there's not much good in terms of what you want, then there are strategies that silk's can adopt, either suggesting that we need a second junior, and then you wheel someone in who you know will do what you need them to do, or alternatively you engage a secret junior to do research. Like if I think that there's a hole that I haven't got time to fill, I might engage someone off my own bat and pay for them directly to do the work that I think needs doing and should have been done. So there are those strategies, and sometimes if you're junior, you might be the beneficiary of that. If you're competent, you might get a call saying, can you do this for me on the QT? Or are you, if the solicitors and the client are happy, are you prepared to come in as a second junior? So again, if you've made a good impression, you might find you end up as a second junior in a big case that can help you. So that's another reason for doing the good thing. If you turn in the paper itself, then I dealt with about finding out about the silk. These things are sort of, a lot of this is bleedingly obvious, and yet, as I've already apologised for, it hasn't really happened. I haven't been good at it as a silk in my own right. In the assistance that I had from others, when they've talked about good experiences with silk, they've talked about how it's been a collaborative experience. where they feel like they've been part of a team and they've been respected. And so that the silk has been happy and keen to discuss issues and bring you into the frame about what they're thinking and what's trying to achieve rather than leave you out in the cold. I think one comment I got from someone is that was that a proposition was put by the silk in the case that the junior had no idea was coming. So you learn from the first time that a certain point was going to be advanced. Now that just shouldn't happen. And I think Simon shared with me the idea that, and it's happened to other people as well, that all of a sudden you say, you cross-examine this witness without having been given much notice. Well, you take this witness, I'm feeling a bit ordinary. If there's going to be any discussion about who cross-examines what witness, that needs to be done well in advance and not just dropped on you like a stone. It's a bit like going to the full federal court when you don't know anything about the case. But I don't want to labour that. It hasn't impacted on my life at all. I'd forgotten it until today. So a lot of this, when I drill through it all, it came back to the inside of the silk. Everyone needs to be insightful, but the senior person with carriage of it really should be thinking about what have I got to do to ensure that I'm getting value out of my juniors and treating them properly and making them feel like they're relevant. So that's sort of the message. The other thing I think Patrick Barry mentioned in a note that he helpfully prepared for me, which was there are different considerations, at least at the start, as to who gets whom into the matter. Like if you are in the matter and you get a silk in, then what can you do? Where do you start in those circumstances? And it's quite different to circumstances where the silk's in the matter and they're getting you in it. And I thought that was a pretty telling point. And it dovetails with Richard's experience as when silk are brought in on appeal. Then the junior has run the matter and should know everything about it. And if you've lost, then one of the things that's important, and I've used it in here as an example, the junior needs to be candid enough to say, yeah, look, I think I made a couple of mistakes, and let me take you straight to them. This is where I went wrong. I failed to call evidence on that, or we did this, or whatever, and now I want you to help me to see if we can bail ourselves out of this. So you don't want to get into a matter leading a junior who's acted below and only find out through your own investigation that they cocked it up. That should be something that they tell you straight up front, so that you might look at it and say, Jesus, that is a major problem, and we better think earnestly about whether we should maintain this appeal. Are we wasting our time? So I think that idea, the candour is bilateral. You need to be very candid with your silk about your availability, and I've laboured that somewhat because it's one of the areas that really used to bug me a lot. But you need to be candid about other things. If you're out of your depth, and some of the juniors who commented said this, and it's quite right, if you're asked to do something and you really think it's beyond your capacity, then for God's sake say so. You never get any marks for saying I'm going to do it and then not be able to do it or to screw it up. The candour aspect is there at all material times. And I think I've talked to a number of you about this idea up front. If you're offered a brief and you're keen to take it, say, you beauty, I'm going to get a work with a silk, and then you try to play hooky and fudge about your availability, you say, I've got a lot on, but I really want to do this, you're better off to say straight up, I really appreciate you giving me this chance, and I'd really like to work with you, but I can't do this matter. My other commitments are such that I cannot commit to give you the level of preparation time that will be required and that you'll need of me. That will give you a big number of brownie points, and it'll be the opposite if you fudge and say, I am available, and then it turns out you aren't, right? And that will be ascertained by all sorts of means, some of which are mentioned here. When juniors say, I'm happy to do it, and I've got you need that done next week to work it up for the week after next. I've got 3 full days I can set aside for that. Then I rely upon, in choosing the junior, I rely upon that heavily. And then you find out when you ask the clerk, well, where's X today? I took a district court matter yesterday, they'll be back at 4:30. I've almost got a cab and gone down there and said, and just grabbed the barrister by the throat and say, Your Honour, he's withdrawing. His instructions have been withdrawn. And he's doubled. Anton. He's starting to worry. There's a guilty... I think there's a guilty conscience here. So that's an important thing. If you're going to commit, you're better off to say no than say yes and then struggle. Don't say you can do something if you can't. If you agree to do something and you find it's out of your depth, just say so. You know, that's so that in one sense it's bleedingly obvious, but people feel, and I understand the pressure, especially if the silk's a hard ass or a difficult person, and of course there's 3 or 4 of those at the bar. You might be more candid, less than candid than you need be, but you have to protect yourself. So I've talked about what you need to do do your own investigations about the silk you're going to work with. Do it directly or indirectly about finding out who they are and what do they like, their likes and dislikes, and then try to fit in. And then, as I've set out, the matters that I don't like, about knocking it back. If you take the matter, get straight onto it. I like the idea that a couple of people talked about, and I know that there are barristers that I've worked with who aren't on this floor, who are very good when they get into a matter, and it's not just me, obviously they do it as a matter of routine, but they are very proactive, and I think Patrick talked about that as well, that when they get briefed, they figure out what can I do immediately to show that I'm on the ball and I know what's got to be done. Don't wait till someone says, oh, can you do this or can you do that? Say, look, I've already done this and I prepared that, and here's a detailed chronology, and here's that, and all of a sudden Silk's saying, that's terrific, you know, that we're really... So be proactive and show initiative. Don't sit around and wait and told what you're going to do. That will help you enormously. So the idea of completing things on time when you do say you're going to do it. When I look back through this now, and it happened to me many years ago with a junior who is now a prominent silk, who undertook to do written submissions in an unfair contract case of some complexity, and the submissions were due, probably had about 3 weeks, more than enough. And every time I called him to say, well, you know, I haven't seen a draft, where is it? You know, yeah, it's all going to happen. And about 3 days out, I said, look, I have to have it today. And I got a cut and paste dog's breakfast from other cases that the junior had run, and it was so discursive and useless that there was the applicant's name from other cases was in the material he sent me. I had smoke coming out my ears for and apart from the disrespect and the dishonesty about that sort of saying, yes, I'm going to do it, yes, I'm going to do it, and don't worry, you can trust me. Not only did he let me down, but it then put the pressure smack on me. I had to start from square one to draft substantive submissions in a couple of days. Now, for me, that's unforgivable. I wouldn't then, if I was working with that junior again, I would never assign them the task of doing a draft submission because I just can't trust them. So I'd do it. So, righto, I'm going to do that, and then you can have a look at it when I've done it. So there are certain bugbears that different people will have. The other thing that Fiona mentioned when I showed her this draft paper from the clerk's perspective, the clerk has... I didn't speak too much in this paper about the role of the solicitor, but the relationship between the silk and the junior, you've got to manage also the role of the solicitor. Like if the junior's playing hooky with their availability, the silk will get annoyed, right? Saying, well, where is he? What's he doing? You know, why isn't... And the solicitor's doing the same thing with the clerk, ringing up saying, look, we're trying to get dates for the continuation of this matter. Nothing in his diary, or I can't find him, I don't know what's going on. And that causes problems in the professional relationship. And so you need to... your clerk needs to understand how you roll, and you need to be candid with her, even if you want her to cover for you. You've got to tell her what the real position is. And of course you don't want to let any silks down, especially if they're on your own floor, because they'll come around and drop their knees into your back sometime. So that's... The other thing I think I might have mentioned before, but if someone lets you down when you give them a chance, and they've effectively, you know, just not been candid about what they can do for you, the final point is that because you haven't got one person to choose from, you've usually got half a dozen. Some you know, some you don't. And so if you end up choosing someone and they let you down, you say, Jesus, I wish I'd hell if I'd have chosen X, I know this would have been done. And so it's the lack of opportunity to get someone who's going to do what you need that you're robbed of if someone's not completely candid with you. So that's a lot of the preparation stuff in global terms, and it's all there in the paper. But the other thing is the court room itself, about what you do and what your role is. I think it's very important that you know what the silk expects of you in court. You know, and I don't think I've been good at that in terms of making it abundantly clear what your role is, what I think the solicitor should do and how the whole team should work. The silk should really be saying, especially if they haven't worked with the solicitors or the junior before, now let's sit down and let's talk about how we're going to run this. Who's going to do what? Let me tell you how I roll, and then get it all sorted. It's a big team effort, and I think a lot of silks assume that this all happens by osmosis, that everyone around you will know what you want and what you don't want, and that's a mistake. I think the other thing that's come through about the court work is that at the bar table as a junior, you really need to be 100% attentive, and like the eyes and ears, do everything that the silk would be doing if he or she wasn't on their feet. You really got to be in it, in my view. You can't afford to sit back and say, well, as a famous story that Kenzie likes to tell, when he was asked to lead a junior, reasonably senior junior in an industrial matter, and the junior was audibly heard to say, "You beauty," and immediately picked up his phone and said, "Yes, I can take that bloody case next week because I'm now being led in the other matter." No, that's an embellishment. But that's the import of getting excited about being led and saying, I can now put my feet up and do squirt and still get paid. So you want to be as active as you can in court, no matter what the situation is, and you need to know what your silk expects of you when you're in court. And that has to be a dialogue. Because if you get it wrong, again, it can hurt you enormously. The issue Robert Goot made a comment about in the draft when I talked about postage stickers. Strangely enough, it's the same junior that I've got the effigy of at home that I still stick pins in. He had this habit. I've only ever seen it once, but it was remarkable. He must have brought to court about 700 postage stickers, and every minute there'd be one. The hand would come across, and the postage sticker would go. I couldn't even read what the bloody writing was, let alone understand what the point was, and it was so distracting. Eventually I said, no more postage stickers, for God's sake, And it just highlights about the discretion that you have to have about interrupting someone when they're on their feet. It's not an easy area, but it's certainly worth a discussion. You need to say, Kenzie's got a wry smile on his face because in all the years he led me, I was prone to interrupt sort of a fair bit. Lucky he didn't wear robes because I probably would have jerked them off his back. His suits looked a bit ripped eventually. But Richard was always collaborative and not too hard on me for the interruptions, and eventually when you work together a lot as we did, you get to know what's tolerable and what you don't do. I think the bottom line is less is the way. If things are very important, then obviously if something's been said that's clearly wrong, or you're going down a track that's clearly wrong, then you need to say, hey, listen, I've really got to tell you that, and if the silk trusts you, they're going to stop and realise that you're not wasting their time, that this needs to be said. Otherwise, wait for a convenient time, informal or formal break, where you say, hey, listen, Kenzie and I had that in the High Court where David Jackson put a proposition in a multi-party, the 106 cases that went up, and just, I think, inadvertently or whatever, but he said something that was clearly wrong and contrary to the position of our end of the bar table. And so during the morning tea adjournment, we went to his chambers and said, in the High Court, and said, David, that point you made just 10 minutes before the break, regrettably, that's just not correct, and you're going to have to find a way to withdraw it. And he was terrific, as he always is. He said, my God, he hadn't realised that he'd overstated a proposition such that it was contradicting an arm of our case. So if you're in the junior chair and something like that's happening, then you have to be attuned enough to know when someone's making a mistake, a big mistake, and you need to then pick the right time to correct. But again, just as the paper says about the differences between silks, Michael Cranich, he gave me some helpful thoughts. His practice in personal injury is wildly different from what I do, and his expectations of what the junior does is wildly different from mine. So it is horses for courses and the nature of the practice. As to just how involved the junior will be and what the expectation of the junior is. And that's why you need to know, depending on the fields you're working in. That brings me to the point, you might have, those of you who at the RISE conference heard Brett Walker, or might have heard Brett Walker talking about how he expects in his practice, and of course by and large that's appellate and High Court, but he said, my view is that juniors should be in a position to stand up and take over from me if I fall down or something happens. and to which everyone goes, oh yeah. You know, and that would be the exception rather than the rule. Although I know Robert's had experiences where he stood up and took over and won some local court matter that was worth $10. Did you tell me? Was that the nature of the matter? He got dumped and went on and won the case. I'd spoken to Simon about this. Is an interesting question about whether you can carry on. Is it feasible? And then what's your brief? Like when you are briefed with a silk, and it might be a complicated matter, the junior might want to say, just let me make clear what I'm not briefed to do. I'm not briefed to take over. So if the silk falls over or doesn't front, what I'll be doing is applying for an adjournment. Is that agreed? That I don't want to get forced on because I can't do it. And you don't want to have to feign a heart attack, you know, to fall down. And so it's funny, I'd never thought about that before, but it becomes front and centre. Ordinarily, you'd expect that the solicitor wouldn't want it and the client wouldn't want it. I think for what Bilal or Lachlan said in his note, if you're paying real money or big money for a silk, the idea that you say, oh yeah, I'm happy for a junior to carry on, they're saying your dreams. You're now instructed to either hand your brief back if they're forcing you on, which sometimes happens, or alternatively, you're now instructed to ask for an adjournment.
Michael Kirby and Peter Gray did it.
Yes. Well, that's
They
right.
stood up when silk collapsed.
Force you on.
No, they stood
took
up when silk collapsed. The silk collapsed literally on its feet. Kirby stood up and took over. The proceeding was never adjourned. Ted Laurie collapsed whilst making his submissions. There was no adjournment. Peter Gray stood up and took over and ran a case that went for weeks. Sometimes happens.
John Zams has been run on as well.
No, silk was carried out. Sorry, man. It happens.
Well, and it was
most successful cases.
And in both cases, it was discovered they'd in fact poisoned the water, and went on to make a lot of money at the bar. Whilst it's not strictly in the context of silk, one of my worst experiences in terms of getting left in the lurch, as it were, apart from Kenzie's case, which I won't remember, it went full federal court and I had to go up there, which I won't mention again. When I was reading in the fourth floor of Wentworth, in the broom closet adjacent to Richard and Cranitch's room, where they had the smoke was so you didn't even know when they're in because you couldn't. You had to say hello. Is there someone in there? Because they smoked about 60 a day. Jim Curtis asked me to gave me a big brief with a ribbon around it. In those days we had briefs that had ribbons around it, and said go over to the district court and adjourn this matter. And Muggins says all right, so I go over there and I walk into Harvey Cooper's court, and he wasn't a very nice person indeed. He was a pig. I think he's dead. Will someone check that quickly? Either that or he'd be 160 now, I'd reckon.
Just pause that while we check.
And I walked in and there's about 60 people sitting there waiting to be a panel. Jim was holding the brief for the plaintiff in a jury trial, and he sent me over to adjourn it. And Harvey Cooper said to me, Mr. Kimber, he says, you're here holding the brief for the plaintiff, aren't you? I said, yes, Your Honour. I said, no, I thought, I'm not really. I'm holding it, but that's... that, I can put that... I'll put it down and say, I'm not holding this brief. And he said, well, we're ready to impanel the jury, and this matter's ready to proceed. And then I didn't think of the heart attack, although I would now. He was having a great old time making me sweat. And then he asked me who'd been the previous counsel in the matter, because he then realised that I knew nothing about it. And he directed that Curtis attend on his chambers, later in the day, because it was a disgrace. He should never ever have done that. So you need to be, I suppose you can get a sniff about, it's all very well to say, juniors should take whatever comes their way, but you better be careful or try to figure out where it's coming from and whether or not it's a hospital pass that you're not prepared to entertain.
Should you have said no? Should you have said no?
Yes, I should have said no.
Exactly.
The reason he was adjourning is because he was jammed.
Yeah.
In those days, these guys they worked on the idea that they could settle and they'd end up running one, but they were prepared to do it with common law cases. Workers' comp was notorious. But the world, and I hated it, their view about their client's interest was just virtually zero. It was only what works for me, and I didn't like it. So you need to know...
Can I trump that story?
Yes.
With junior barrister who went out to try and adjourn a matter before Hutley. And Hutley wouldn't have the power of it. And he said, who's briefed in this matter? I prefer not to say, Your Honour. Who's briefed in this matter that set you up to adjourn it? No, Hutley, Your Honour.
Oh, he said, and that's all right then, matter adjourned.
On the other hand, the John Steele story.
Yes, Kenzie, in fact, Richard should tell this story because it is in the zone of the idea of taking over from someone else. Why don't you tell them the story?
Okay.
Do you want me?
It's not a film? Okay, I'll tell you. It is a true story. So John Steele, who became a family court judge, was a member of our floor, and he received a junior brief to the Solicitor General in a family court case which turned out to have constitutional implications, and he found himself being led by the Commonwealth Solicitor General in the High Court on this afternoon, where the matter was adjourned at 4:15 with the constitutional case about to start. John arrived at the High Court the following morning, and the Solicitor General has a room at the High Court on the 6th floor there, where his own facilities, and John went to the room at about 9:45 and was greeted by these words, "Mr. Steele, thank goodness you're here. The Solicitor General has been called away to advise the Prime Minister on anti-terrorism legislation, and you're to conclude the constitutional submissions this morning at 10:15. I said to John, what did you do? There's this, if you go up to the 6th floor on the High Court, there's this glass area there where you can look down on the grass about 6 stories below. And he said, I looked out.
If I could get the window.
I thought about it.
He said if I could get the window.
If I could only get the window open. I'm not going to go on. Anyway, he was guiltless, but you can get yourself into that situation. Sorry. I'll sit down.
I don't actually know whatever happened with that. He probably pulled the rumpole stunt, did he?
Yeah, he did.
Yeah.
It was a journey.
But I think what Brett says is it might be so in rarefied circumstances, but I think as a matter of course in a lot of cases I would think that the junior wouldn't be in a position to take over and run the case, or at least all of it. So, but it needs to be thought about, like, are you in a situation where there's that expectation? There's no doubt as a matter of practice and in terms of your own development, to the extent that you can get involved and ask yourself, how would I do this? What would I have done? How would I run this case? Would be very helpful practice to adopt, obviously, especially if you see the way the Silk's doing it and say, Jesus, if I'd have done that, I think I'd have done that differently, or I'd adopted this approach. And I put that down there at the bottom of page 8, which I've started to do more commonly now, and I'm finding it very fruitful to say to juniors, well, what would you, just tell me what you think the most important matters are, what are their best points, and how do we deal with them? If you were cross-examining this person, what would be the questions you'd ask? And then it's interesting, in a matter that I had with Glenn and another junior, they both came back. It was very helpful on the day that I was addressing. I then had, after my own working up what I wanted to say, I was then able to look at their notes, prepared separately, and to say, my God, that's interesting, and was able to work in their thinking. So I think it's a useful approach. So the other aspect of this that in conclusion, almost in conclusion, is it forces you to focus as a silk on why do you want a junior in the case. And your expectations and needs might vary dramatically depending on the case. But you need to figure out as a silk, well, what do I want? What do I need? And then you need to tell them. So I want someone who can do this, this and this. Are you able to do that? Yes. Can you do it in this time frame? Yeah, I think I can. Okay, well that's good. And if you can't do it, then say so. And similarly, so if you're getting silk into a case, it might not be your call, and obviously some juniors get their noses out of joint when the client or a solicitor says we're going to bring a silk in over the top of you, and the junior thinks, well, I don't really think I need to be led, not your dog. If they're paying the freight, then you say, okay, then start to think about it. If a silk's being brought in over you, then you need to say, right, now what can I do to help them and get them into this case that I know everything about, or you should, because you ran it. How can I get them in and make them feel comfortable, and then decide and have a discussion about how we're going to divide up the work, and this will usually be on appeal, of course. So here I was starting to think about what do I want my juniors to do, and I've opined about that in the paper, about things that I am in the school that says I think that I like to have competent juniors who can do a fair bit of the work. That's what I want, so that I can focus on what I think I need to do, prepare the cross-examination, figure out the case strategy, draft the submissions if need be. Sometimes I do it straight after the case finishes. I just dictate something, because that's when you know most about it, and then say to the juniors, take that away and work that into something that you think might be useful by way of a final address. So yeah, Silk need to do it, and juniors need to say why they're if a Silk's coming in, then how's this going to work? Who's doing what? So that's pretty much. And what I did, as you can see, it looks like it's repetitious, which is often said about my submissions. But on page 10, what I did is that I wrote down my do's and don'ts. I dictated them and thought, this is really what I think. And then I circulated it to the other silks on the floor. I asked the other silks on the floor for their do's and don'ts. I think I did that without them seeing mine. Did I? I can't remember.
No.
Did I?
No, that's all yours.
No, we saw
I
it.
sent, yeah, and that's right. And said, well, what do you think about this?
You sent it by email. And
No, I didn't.
I know.
hard copy,
I now know why you done it.
Someone else.
Just-
You don't do it.
I did ultimately print that off. It's true, I did ultimately print. Did I not correct that stuff that you mentioned? So you can see there, silk, some of the silks then I got responses from, and I've worked and often expressed in shorter version, which is not unusual, but to the point. So what you see from page 10 and 11 is other silks' views, and I've also incorporated where it's been helpful the views of the juniors, who are also then asked to. I don't think did the juniors see the paper when they were asked for their comments on do's and don'ts?
No, not sure.
Yeah.
I don't think
So I just wanted to get that cold without them being influenced by what had been said by the silks, and I thank those that responded, and their thoughts are incorporated in these paragraphs too. So look, I think that's all I need to say about it. I was hoping, and I am hoping, that if anyone else other than Richard and I and Robert have got war stories, I think it's very instructive when people say, if they can say either from the silk's perspective or the juniors, something that you really found difficult or offensive or whatever it might be. Like Simon, I'd be appalled if a silk had done that to me. He said, you should start you cross-examine this witness. Like, Cole, what are you serious? And then you're in an embarrassing situation. So what am I supposed to say? No, I won't. They say, Jesus, you're weak. But you want to be in this case, and I'm giving you this great opportunity, you're not taking it. So you're really in the meat and the sandwich. And can I disclose the name of the silk? He wouldn't tell me.
No, but we're trying to guess who the junior was that you were referring to earlier.
Oh yes, well you can guess away. I'll never give his name up.
You did say he's still a junior. He's a silk.
I think it's Shane, actually.
Sorry.
No,
Yeah.
it's in preeminent. All right. Good point. It's not me.
But just finally, whilst there's obviously a lot of pitfalls, and people do have bad experiences with silk, either because they feel that they're not valued or they're not treated well or whatever it might be, overworked, underworked. It's good to hear, and this came from a number of the juniors, this particular quote from a response I got: the most enriching times, both personally and professionally, in my time at the bar have been from working with silks. The majority of the time it's a privilege. So that's what you're aiming to achieve, where you get a lot out of it and you feel like you've added value. So other than that, I've got nothing to say. So